Oyez, oyez. The Honorable Court of Appeals for the 11th District of Texas is now in session.
Thank you very much, Mrs. Williamson. Mr. Rice and Mr. Lindsay, we appreciate you doing this by Zoom today. To introduce folks quickly, ordinarily I would say sitting to my right would be Chief Justice Jim R. Wright, but he is not actually sitting to my right because we have to spread out to do a Zoom hearing, or else we have that background noise coming from each other's computers. But Judge Wright is positioned in our current courtroom. And as this fact just dawned on me, we're also joined today by Judge Stacy Trotter from Ector County. He is actually in our old courtroom. I never would have thought we would have had an oral argument that we used both courtrooms at the same time. But technology has an interesting way of doing things. You may be rookies to Zoom. I'll tell you right off the bat, the biggest thing is the mute, unmute. I learned that just a second ago because I was unmuted in Zoom, but my computer audio was muted. So it's no big deal. If you're on mute, I'll put my hands up or I'll say, hey, you're on mute. It's no big deal. We work through some of the technology. At least on my screen, you'll see up in the, or mine has it in the upper left-hand corner, it says we're live on YouTube. We are doing that to comply with the mandate that our court proceedings be available to the public. No earthly idea who may be tuning in to watch our arguments today. I say that not so much maybe for this case, but I know that you gentlemen have another case coming up later today that has some sensitive facts in it. I know full well that both of you will use your discretion in that. I probably won't make a comment at the start of the argument in that case because I'm taking care of that right now. But I will tell you the court is thoroughly familiar with the facts of the case, if that helps you in aid of your preparation for the next argument. One additional matter that I'm going to take advantage of because I have both of you here, I'm going to talk to you about some matters that in cases that don't have anything to do with Jones. And it has to do with some termination cases that Mr. Rice is involved in. And Mr. Lindsay is on the other side. I make this statement to say this. There is some elements of Anders in a parental termination case. You'll see some orders. I think they'll come out tomorrow. But it's different in the parental termination case as far as what procedures we have to follow. And there's going to be an order issued in one of those cases. It cites a case called In Re PM. I would recommend that both of you review that for its effects, for what it does on what an intermediate court of appeals is entitled to do on a motion to withdraw. And that's all I'm going to say. It's cited in that order that's going to come out tomorrow. You can find it and see. So with that, we'll go ahead and proceed on with our argument in this case. Court would call cause number 11-1983 CR, Jones versus State. Mr. Rice, are you ready to proceed?
I'm ready, Your Honor.
Thank you.
Thank you. May it please the court and counsel. My name is Charles Rice. I'm the attorney for Cookie Jones, the appellant in this case. And this case started with the sale of a house, of real estate. We have the seller, who is Sharon Winchester. We have the buyers, who are the Kennedys. And then we have the appellant, who was a friend and acquaintance of the seller, Sharon Winchester. The Kennedys purport to be somewhat sophisticated buyers. They have about, the testimony was 20 houses, rent houses that they own in Abilene. And they entered into a handwritten contract with Winchester to purchase her house. I think this is maybe a 3-sentence long handwritten contract. There was a verbal agreement as to the contents of the house, whether or not that would be included in the sales price. The Kennedys insisted that they purchased all of it. Winchester said that she only was going to leave, quote unquote, the heavy stuff she could not move because she had no help. At closing, the price was reduced. Again, the reasons vary a little bit. The Kennedys allege that Winchester sold valuable parts of the contents that they wanted, so they reduced the price accordingly. Winchester's version is that the Kennedys told her it was going to cost them $5,000 to clean out the house, and that they reduced the price accordingly for those reasons. In any event, the closing was held on Friday, at which point the Kennedys went to the house, changed the locks, and secured the house. Now, over the weekend, they allowed Winchester access to the house to blow into her breathalyzer, which I think was a requirement of her probation. And I think either Sunday or Monday, my client, calls Mrs. Kennedy and says, "When can we go get Sharon's property? It's in the house. It's locked up." Mrs. Kennedy says, "We own all that. Then you're not allowed in there." And at some point, I think that evening, Mrs. Kennedy drives by the house, sees trailer there, and people unloading stuff out of the house onto the trailer, contents of the house. She sees Sharon Winchester at the scene. She calls the police respond and say they're coming to investigate a burglary by Sharon Winchester. At the scene, Winchester says she's not there at the time, but that she ultimately shows up a few minutes later. My client's at the scene, and she tells the police officer the Kennedys are supposed to let Sharon come in and get her property. They've locked her out. She can't get her property. Now, there's no arrest is made at that point in time because there's confusion as to who owns the contents of the property. And as stated earlier, the agreement as to the contents was never reduced to writing. So it was just a verbal agreement. And the police officer, and I think her testimony is helpful here as to why no arrest was made. She said that in speaking to my client, she said Mrs. Jones advised that the Winchesters were supposed to be allowed to let Winchester stay over the weekend. But the moment that everything was signed, I believe on the 14th, when they signed all the documents, the Kennedys went over and basically changed the locks and kicked her out. She was supposed to have time to come back and obtain the property. And Officer Snell went on to testify. That's where it's conflicting information. Calls were made, calls weren't made, times were set up, times were not set up. And then there was also conflicting information that they said, it's fine. And she's talking about the Kennedys. It's whatever, we'll give you extra money to purchase all the belongings in the house. Then the Kennedys would rephrase and say, no, the items in the house do belong to her, meaning Winchester. Question of Officer Snell: at any time during your interaction with the Kennedys, did they ever admit that some of the belongings in the home were Miss Winchester's? Answer: yes. So there was no arrest was made because there was no certainty as to who owned the property. Now at trial, and then I guess I skipped this part where ultimately my client was arrested and indicted for burglary. At trial, Mr. Kennedy asserts ownership. He does say that they were going to buy all of the contents, but he insists that this was a cash transaction, and when a cash transaction buys a house as is, and he seems to believe that that includes the contents. He seems to think that is the law. His testimony is something to the effect of, why was this not in the deed or in the contract? Sir, it doesn't have to be. If it's a cash transaction, when you do a cash purchase on a piece of property, it's in the as-is condition. And he referenced that several times during the trial, and he seems to assert his ownership primarily because it's an as-is contract. They're entitled to do whatever they want to with the contents. Now, Winchester asserted ownership all the way through the trial, and even at the very end, she says, I don't have any property anymore. Why don't you? It was stolen. Who stole it? Richard and Tracy Kennedy. So she accused the Kennedys of taking her property. Now, which gets us to our issue number one, which we maintain that the law requires the state prove ownership of the property in a theft beyond a reasonable doubt. And when you have a bona fide dispute as to ownership of the property, the evidence is legally insufficient to support a theft conviction. And we maintain that there was a bona fide dispute here. At least there was no meeting of the minds as to what personal property was being sold or conveyed with the house and what was being left. Mr. Kennedy says it's as is, which we maintain is not the law. And then he tells Officer Snell, well, yes, she does have property in the house. Winchester only says she only conveyed, quote unquote, the heavy stuff. And we don't know what the heavy stuff was. It's never defined. The contents are never itemized. It's never reduced to writing.
Mr. Rice, isn't it true that your client, Miss Jones, never acquired any ownership interest in the property to be removed from that home?
Correct, Your Honor.
Right.
That's correct. And she did not ever assert an ownership right at all.
Mr. Rice,
Yes, sir.
we can't seem to hear you.
Is that better?
That's better.
I'll move closer. I'm sorry. When we cite the Bocor case, that when there is a bona fide dispute as to ownership, that the evidence is legally insufficient. And here issues 1 and 2 somewhat merge and are kind of mutually dependent, because really, in addition to not establishing the ownership of the property, the other question is her intent. What was her intent relative to the true owner of the property, assuming we know who the true owner is, and that's why it makes a difference. But the evidence shows that her intent was to return the property to at least who she believed was the rightful owner, Sharon Winchester, because she called Tracy Kennedy and says, when can we coordinate a time to get Sharon's property back to her? And when she's at the scene, when the police show up and my client is there, she tells Officer Snell, we're here to get Sharon's property. They locked her out and Sharon needs her property. And the third point is, at the night in question, at the scene of the event, Sharon Winchester was there. At least Mrs. Kennedy says she was there, and then Sharon Winchester admits to being there later, and always asserts that that was her property. So my client's intent was to return at least whom she believed to be the true owner of the property, Sharon Winchester. Like I said, so here we really have a hard time discerning, or the ownership issue impacts the intent issue, but it doesn't resolve it. Because if the Kennedys are the true owners of the property, then, which should have been established, if they were the true owners of the property, then my client has a mistake of fact defense. If Sharon Winchester is the true owner of the property, then she was only trying to return that to the true owner. So we really can't resolve issue 2 until we resolve issue 1. And which kind of leads us to the jury charge. And the jury charge defines owner under the penal code as someone with title, a party in possession, lawful or unlawful, or a party with a greater right to the property than the defendant. Well, that doesn't really answer our question either, which is why this is a civil dispute, and the statute doesn't. It's not really workable here, because if the Kennedys are in lawful possession, if they're the owners in unlawful possession, that's one thing. But then again, or if it's Sharon Winchester's, then she has the greater right to the property. So the code provision doesn't really work well in this case, and that's because it is a civil dispute. And when you have a civil dispute like this, the mens rea for theft is negated. Now,
excuse me just a second, Mr. Rice. You'd mentioned that this is kind of a follow-up to Judge Trotter's question. You had mentioned that this was a civil dispute. As far as your client is concerned, where is the civil dispute between her and anybody?
Well, it's a civil dispute between the purchasers and the seller, between the Kennedys and then Winchester.
Wouldn't wouldn't Ms. Jones have to be a party to that in order to claim this? In other words, can the bona fide dispute exist between the stranger to the ownership question?
Yes, Ron, I think we cited, I think it's the Hahn case. I think it was the landlord-tenant case. There was a dispute between a landlord, two people with property interest, and whether or not, I think the tenant to the landlord, which we cite in our case, was accused of trespass, and there was really a dispute between two property owners. And I believe, as we cite in our case, that the dispute between who owned the property, as I read the case, would benefit to the criminal defendant in that case, to the who thought he was trespassing, which would be similar to this case. But I understand your question. She was not in contractual privity with anybody in that case, but I think it goes to ownership of the property, and the ownership issue still gets us back to what her intent was. Had she known that the property was the Kennedys, and that was ascertained and determined, and she knew that, that's a different story. But in this case, the property the ownership is in dispute, and she was operating under the impression, the evidence would indicate, that Sharon Winchester owned the property.
Thank you,
Mr. Mr. Rice, in this case, who do you claim the bona fide dispute exists between? Which parties or which persons?
Between the Kennedys and Winchester. That's the dispute goes.
Mr. Rice,
Yes, sir.
once again, you're quiet.
I'm gonna have to change my microphone, move it up a little bit. The dispute
Okay.
is between the purchaser, the Kennedys, and Winchester. That's where the dispute goes. But the dispute really still has to determine who has ownership, because then ownership then drives the question of what the appellant knew and when she knew it, and it impacts on her intent. And for those reasons, we'd ask that the evidence of mens rea for the intent to commit theft is not there, and no rational finder of fact could so find. For those reasons, we ask that this judgment be reversed and that she be acquitted of burglary. Thank you.
Thank you very much, Mr. Rice. Mr. Lindsay, are you ready?
State's ready, Your Honor.
Go ahead.
May it please the court and counsel. Good morning, Your Honor. I know I say it every time that I'm going to try to be brief, but I really mean it this time. I think this is a case where this is a more difficult question for jurors than it is for the reviewing court, because you have a sympathetic defendant. It's tempting perhaps to say that if one or the other of us were sitting on a jury that we may have found differently. But of course, all the case law regarding legal sufficiency tells us that we're not to act as we being the court, not to act as a 13th juror, that the only question for the court is, was there evidence presented that the elements were met, even if there's conflicting evidence on the other side? And if that is met, then the evidence for burglary is legally sufficient. In the cases that the appellant presents, the Jacobs case, the Beaucourt case, the Stockton case, the reasons we'd submit to the court that those didn't survive a legal sufficiency challenge is because there was not only a contractual dispute in those cases, but one that even if the complaining witness / victim's testimony and version of events were believed, that even if they were proven true in a light most favorable to the verdict, that it's still a contractual dispute, that even if that testimony is 100% correct, that there's no criminal intent element. For example, in the Jacobs versus State case, the defendant failed to perform the work that was contracted for, but the court found there's no element of deception. The evidence only showed that he, quote, failed to perform a modified contract, that he contracted with the defendant. There was some questions of impossibility. They modified the contract. He agreed to erect a building, install a sink, change a light fixture. He worked on that some. He demanded that the complaining witness pay for the concrete. That witness refused. He stopped work. It was essentially a contractual dispute, and there was just no element that the defendant intended to defraud the complaining witness. In the Bocor case, there was a bona fide dispute over who the actual property owner was that the court found had to be figured out in a civil court. As the court put it, the questions were, did Trimble, the complaining witness, breach the contract? Was the appellant's notice of contract cancellation appropriate? Was the third party's lien valid? Clearly, these are questions that should be answered in a civil action. There was no element that showed that any person acted with criminal intent. In the Stockman case, the appellant's attorney and the complaining witness's attorney actually exchanged correspondence between the two of them that indicated that each considered the other one to be in breach of contract. There's no element showing that anyone stole anything from the other person. And the Potter case, which the Eastern Court quoted approvingly later in the Jacobson case, is different because the testimony of the appellant and the victim are at odds. If the appellant's testimony were believed, then yes, there's a contractual dispute. If other testimony were believed, the victim's testimony, then the defendant had criminal intent. The appellant said the signs that I took, the property was in settlement for work I performed, but the victim said that that was not true, that we did not bargain for those signs. And the court found that the jury was entitled to believe the victim's denial that the signs had been explicitly bargained for. So the conflicting testimony going both ways in that, the court found if we take the verdict in the light, or take the evidence in the light most favorable to the verdict, then the jury believed this witness and not this one. And that is legal sufficiency analysis in a nutshell. This court quoted that approvingly in the Jones versus Patterson case, which is a civil case, but dealing with the Theft Claims Act. So it had questions of criminal intent involved, and quoted the language from the Potter case that I think is the crux in this case as well. While a property dispute may negate the requisite criminal intent, the focus of our inquiry is not whether a property dispute existed, but whether the requisite criminal intent exists. So in the instant case, the only question before the court is, was there enough evidence presented to prove that the elements of that offense were met, including the criminal intent? And that's even if there's controverting evidence on the other side. If it's a she said case, then we go with the she said that supports the verdict. And going through each of those elements really quickly, of course, a burglary of a habitation, you can only be found guilty if it's proven that the person entered a habitation without the effective consent of the owner, in this case, to commit a theft. And there's no dispute here that the appellant entered a habitation without the effective consent of the owner. Ms. Kennedy testified that afterwards, after the title was signed, they returned to the house. They had the locks changed, and they let Ms. Winchester know she couldn't be there without them or their direct permission. Now, she did have property remaining in the house, to be sure. That, for example, her sobriety monitor was there. She was on probation, which is felony probation, I believe, which is one reason why she had to sell the house. They had to make arrangements to let her in to blow to her stationary monitor 3 times a day, I believe, for her probation. and they or their maintenance man let her in over the weekend, but kept the house locked for the remainder of the time. And their testimony was it was understood she was not to be in the house at those other times. Ms. Kennedy testified that they returned to the house, they changed the locks, they screwed all the windows shut. And Ms. Kennedy said that she did not give Ms. Winchester or the appellant permission to go into the house on that day, that they were there trespassing, basically. Said that the maintenance man said that entry was gained next to a window that was broken. A board was removed next to the air conditioner so they could go in and get those items. And as far as the intent to commit theft, well, once again, if the testimony that supports the verdict is believed, then yes, there was intent to commit theft. Mr. Kennedy said, again, they said that they hadn't given anyone permission to be in the home and had not given anyone any permission to take any of the property. They said that the heavier items in the house, they said that they had bargained for the things that were in the house, and that was why they had reduced the property, reduced the price on the property. Ms. Kennedy said that she had spoken with the appellant that same day, and that she said, she explained clearly to her that everything was already out of the house that belonged to Mrs. Winchester, and that Mrs. Winchester was no longer allowed to be on the premises while they were there. And that testimony, if the jury believed it, which they did by their verdict, that establishes criminal intent right there, that they told the appellant that you're not allowed to be on the property, that nothing in that house, there's nothing of value that belongs to Mrs. Winchester anymore. And she went into the house to retrieve the property. Mrs. Winchester's testimony, I think, was really kind of the nail that drove the nail in the coffin for the appellant's case, because Mrs. Winchester essentially said no, that the heavy items in the house, yes, they did bargain for, yes, they belonged to the Kennedys, and those were the items that were loaded on the flatbed trailer. That said that Ms. Winchester was asked point blank, so there was a verbal agreement that they were going to take the heavier items in the home, and she replied, correct, that I could not move. And just for additional clarity, she was asked, was there property in that home, some of the stuff that you agreed the Kennedys could have? And she replied, the heavier stuff, the heavy stuff. And she was asked, did you tell the appellant that you had a right to some of that stuff in that home to go get? And she said point blank, no. And again, that establishes criminal intent right there, that she said, I never told the appellant that I had the right or continued ownership of those heavy items. Yes, I transferred it to the Kennedys, and the appellant broke into the house anyway and retrieved those heavy items, loaded them onto a flatbed trailer. And she was asked if she directed the appellant to go to her former home on October 17th. She said she did not. She said that she knew she was going, but she did not believe it to be in her best interest. Now, she appeared to not be particularly happy about the sale of the home. She was again on felony probation. She did not appear to be in a good financial situation, and I think, and she was pretty unhappy, it appeared at trial, with both the Kennedys and with the appellant. It seemed that she was upset with the Kennedys for get the distinct impression that she felt like she was not treated fairly in the sale of the home and in the items that were still in the home. And she was not particularly happy with the appellant for retrieving those items and causing her further legal problems with her felony probation. But if you break it down very simply, the answer to the question is just, was there evidence presented that a rational jury could find that those elements were met? And regardless of whether there's conflicting evidence on the other side, yes, there was testimony that burglary was committed, that that house was broken into without the effective consent of the owners, and that it was with the intent to commit theft of the items that were inside that had been transferred to the Kennedys. And put simply, I think that's the only question before the court. And I took longer than I anticipated, but it was not as brief as I'd hoped. That's all I have, unless your honors have further questions for me.
I have a question for you, Mr. Lindsay.
Yes, sir.
Appellant's position is that there is a bona fide dispute as to ownership, which would invalidate the conviction. What's the state's position as to who the bona fide dispute exists between?
I don't believe there is if there were a bona fide dispute, then I believe that it would be between Mrs. Winchester and the Kennedys. But it's the state's further position that it would only be a bona fide dispute, as in the Beaufort case or the Stockton case, where both parties, if their testimony was believed, that there's a contractual dispute. And we'd submit to the court that in this case, it's not quite the same as the bona fide disputes in those cases, because if you believe the testimony of, if you believe some of the testimony, then yes, there was a bona fide dispute. There was a dispute rather, but if you believe the testimony of Mrs. Winchester and the Kennedys, there wasn't a bona fide dispute. It was simply a burglary. And that testimony supports the verdict. So that's the testimony that is appropriate for a legal sufficiency analysis. And I hope that answered the question. Anything further in my remaining minute, Your Honors?
I think that'll take care of it. I want to make one quick comment. For the next argument, it's a little difficult to hear you. So I'll work on that for the next one.
There's a problem with the microphone on this computer. I believe the microphone is connected to my brand new camera, and I fiddled with it all day yesterday. And
we can hear you.
I may need to stand closer or somehow tweak the settings somehow, but I'll try to work on it and see if I can get IT to do what I can on it.
You just break up. You break up every now and then.
I'm sorry. I'll try to fix that. I think it might be the little mute setting that blocks out background noise might need to be turned off.
Mr. Rice, do you have a rebuttal?
Yes, Your Honor, just briefly. With respect to the heavy items that were or were not removed, I don't believe those were ever truly identified as the heavy items, other than a characterization. I don't recall anything in the record where heavy items were identified or itemized so that they could be properly identified as to what was being moved on the night in question. It may be somewhat subjective as to what Sharon Winchester thought was heavy, because she was a 60-year-old woman who was on a cane. I don't know how that would work, and she didn't have any help, she said, to get the heavy items. With respect to the ownership question, I don't believe that was ever really tried to the jury. The jury wasn't asked who owns the property, and we have an ownership dispute here. And I don't, unless the jury was asked that question, unless that question was tried to the jury, and it wouldn't be in a criminal case, I don't think we necessarily defer to their decision as to who owned the property. I think that's a question for this court in reviewing whether or not the state proved ownership beyond a reasonable doubt. I think Mr. Lindsay, if he's shown any evidence of intent on my client's part, it would be for trespassing, but not for burglary. And again, it was her intent to deprive, quote unquote, the true owner of the property, and the true owner of the property, frankly, is yet to be determined, I would argue. That's all I have, sir.
All right, thank you very much. I need you to hang with me for a second, because I'm going to say the case has been submitted here in a second, and then Mrs. Williamson is going to come on and actually close us so that it ends on YouTube. So with your arguments today, your case has been submitted, and I'll now ask Ms. Williamson to please recess the court.
Oh, yay, oh, yay, oh, yay. The Honorable Court of Appeals for the 11th District of Texas is now adjourned.